Indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all three cases. Is that correct?
That is correct, Your Honor.
All right, and you're going to be entering a plea of guilty to certain charges in these three indictments. So if you will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson, SHANNON
Okay, put your hand down. Now, Mr. Jackson, the state has a series of questions to ask you. If you can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand today's proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
9.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft-spoken. Do you mind speaking up a little bit for Madam Court Reporter? All right. Now, do you understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of a felony, possession of a firearm by a convicted felon?
Yes, sir.
Do you understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement?
Yes, sir.
Do you understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years, which would have to run consecutive?
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by a convicted felon is up to 10 years in confinement?
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185532, in which you were charged in count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for which you could be sentenced is up to 5 years in confinement?
Yes, sir.
And do you understand that for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement?
Yes, sir.
And do you understand that count 4, the failure to maintain insurance, is a misdemeanor punishable by up to 12 months in confinement?
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by an inmate. Do you understand that for those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement?
Yes, sir.
Do you understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement?
Yes, sir.
And do you understand the maximum possible punishment for each of those possession of prohibited items by an inmate is up to 5 years in confinement?
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, the plea of guilty acknowledgement waiver of rights.
Yes, sir. I remember.
All right. And did you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Schardt, are you waiving any potential defects in this indictment on behalf of your client, as well as formal reading of the indictment?
So waived to both.
And Mr. Jackson, do you need any more time with Mr. Schardt? Are you prepared to move forward at this time?
No, sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand there could be what we call collateral consequences to this plea. What I mean by that is that this can have a negative impact on, say, your ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And do you understand that this is a negotiated plea of guilty?
Yes, sir.
which means that your attorney and I in the state have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, do you also understand that if you are under probation or parole, that this can have a negative impact on your probation or parole status? And to be clear, this would not have a negative impact on the offense for which you just were sentenced, as all of these offenses occurred prior to entering this plea. Do you understand that?
Yes, sir.
Now, do you also understand that because this sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also would include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are a convicted felon?
Yes, sir.
Now, do you also understand that there can be, let me get there. Do you understand that you're waiving any and all defenses, including any mental health defenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. At the end, I'm going to ask if you understand you're waiving all of those rights, okay?
All right.
Do you understand that by entering this plea, you're waiving the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alford v. North Carolina, okay?
Yes, sir.
So I'm going to go over each of these indictments specifically as to the counts. Do you understand Alford v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number 23 SC 188183. Do you understand you'd be entering a plea of no contest as to the participation in criminal street gang counts, which is 1 and 2?
Yes, sir.
Do you understand you'd also be entering a plea under Alford v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and the possession of prohibited items by intent?
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested, and the state is not objecting, to an Alford plea as to the count 2, possession of a firearm during commission of a felony, and count 3, possession of a firearm by a convicted felon.
Yes, sir.
And then that your plea would be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you know me, I'm annoying. By taking failure to maintain insurance.
Yes, sir.
Now, Mr. Schardt, understanding that you negotiated these with other attorneys and sort of standing in place, could I fairly accurately summarize the counts for which are the no contest as well as the offer?
Yes, sir.
All right, understanding all of that, how do you wish to enter your plea?
Guilty.
All right, and could that be guilty as to on the 22 SC, the serious injury by vehicle, the entering auto with intent to commit felony, theft by taking and failure to maintain insurance, is that guilty?
Yes.
As to the 22 SC 181814, which is the possession of a controlled substance, the possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon, as to counts 2 and 3. Is that under Alford v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and then the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the Alpha.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you would have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you wanted to challenge the constitutionality of this plea?
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? you understand that you would have up to 12 months from today's date to also file the habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and positively tested, positively alerted as to contraband inside of the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle, Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. Judge, that was a shared cell, and located inside of that cell included a cell phone, the pills that tested positive for methamphetamine. Judge, the quantity would be consistent with the intent to distribute, as well as a shank, which is often used in either self-defense or to be the initial aggressor or primary aggressor, depending upon what day it is at Rice Street. And Judge, possession of Apple AirPods and an iPhone as well. Judge, I'll begin with what the negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on count 1 is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count 2, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count 1. Count 3, theft by taking, is 5 years probation to run concurrent with count 1. And count 4, the failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count 2, that would have to run consecutive to count 3. So count 3 would be 10 years probation, and count 2 would be 5 years probation to run consecutive, for a total of 15 years probation.
I believe my understanding of the recommendation was that was going to be 10, the count 2 was going to be 10 to serve 3 commuted to time served, balance on probation,
Yes.
as opposed to 10 years probation.
I will defer to you as
Big
you were the
difference.
one actively involved in negotiations on this one, Mr. Schardt.
Okay, so if you just go over those again for the record, for count, for 22 SC 181814. Count 1,
Is possession of controlled substance, that would be 3 years commuted to time served. Count 2 would be 10 to do 3 commuted to.
You can't do that if you're going to do count 3, because count 2, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count 3, the possession of a firearm, at some period of time, to statute minimum of 1.
Okay.
So if we're going to get there,
I don't have the indictment in front of me. I think what I meant to say is count 3 Count 3 would be 10 to do 3, commuted to time served, balance probated, and count 2 would be 5 years probation consecutive.
Correct.
The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
All right, so let's be clear. Count 3, 10 to serve 3, commuted to time served, balance on probation. Count 2, 5 years probation, consecutive to count 3.
Yes, Your Honor.
Yes, Your Honor.
And count 1, 3 years to serve, commuted to time served.
Correct, Your Honor.
Yes, Your Honor.
You may continue.
And as to case number 23 SC 188, 183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, the 2 years commuted upon time served. Judge, there are specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of this sentence. He is to maintain gainful employment while on probation. There would be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There is to be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street gang. And there is to be no possession of a firearm on his person in any vehicle in which he occupies nor any residence. Quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Schardt had approached me about concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high-profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Schardt over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Judge, understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present. Specifically because he is already a C recidivist, this is irrelevant, frankly, whether or not we would be able to have three convictions in the future. Judge, understanding as well that the negotiated terms of the larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation, had this proceeded to trial, that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there was other individuals that would have had access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular case. Had a cellular dump been done in this case, and I've been provided with that, that would have demonstrated possession or control or intent over the narcotics or objects inside of that cell, we probably would be in a different situation. But I am not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that if we have a resolution that appears to be amicable to all parties. So just for future no contest cases, I wanted to be able to distinguish Mr. Jackson from other defendants that maybe argued were similarly situated.
All right, thank
That was basically, I don't usually do this, but
you. So will you go over the special conditions again so I can make sure I have them correct?
Yes, Your Honor. The special conditions would include banishment from the Metro Atlanta area, with exceptions for the Atlanta airport. Judge, that would also include that he has to maintain gainful employment while on probation. There is to be no contact or communication, directly or indirectly, with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of a grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept him as a probationer,
That's
correct?
correct.
All right. Anything else?
Nothing from the state at this time, Your Honor.
All right, anything from defense?
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court. His father works an honest job for an honest living. His wife is also present in court, supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity, and I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is, and we only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner, and we're hoping, if Your Honor accepts this plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is, Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he would be allowed to return during the period he's banished? Did the state negotiate?
Judge, again, that was a negotiated term outside of the one. I understand that there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would defer to this court.
Your Honor, I anticipate that at some point in the future, there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that that would probably be the best workaround at this time, and quite frankly, in the future, if things are going well on probation, then maybe we can revisit some of these conditions.
All right. Yes, but you have to tell us who you are for the record.
I'm Ms. Jones, Officer Jones with probation, DCS. Due to the fact that where he's going, if they do not accept his case, we will have to come back in front of the judge to modify the sentence. I don't know that right now, and I won't know that until 7 days from today. I have spoken with my AC, so I am trying to get the situation expedited, but he won't go to see probation until Thursday.
All right, thank you. So essentially what she's saying is until the state that you are moving to accepts your probation, you will be here in Atlanta, and everybody knows that, somewhere in the metropolitan Atlanta area. Okay? All right, as to indictment 23 SC 188183, indictment 22 SC 181814, indictment 22 SC 185532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right, so we're going to start with (22 SC 185532). The negotiated and recommended sentence is on count 1, the defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated to serve consecutive to count 1. Count 3, 5 years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve, 2 commuted to time served, balance on probation to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent to count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay. So the people who used to be your friends or the ones they say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram, whatever.
Not the
They're no
smoke
longer
signals.
people that you can have any contact with. Because if you have contact with them,
Carrier
you run the
pigeon.
risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were, and unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out at 9th grade. You need to go back and get a GED so you can move forward in life. If someone wants to give you an opportunity, you can step up and take it because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process and basically indicates to an employer that you know how to show up and do assignments in a timely manner. That's all they're looking for. You will show up, do the assignment in a timely manner, and not cause any problems. Because you've shown you can do that because you matriculated through high school. So they just want to know you're not going to be a problem, and they don't have to worry about you. And more importantly, the court didn't want to have to look back and say, I just should have sent you to jail, as opposed to going along with this negotiated plea. You're getting a second opportunity. I suggest you take full advantage of it. You're 32 years old. I can say to you, based on what I've seen, the next time you get a felony conviction, you're gonna be looking at a lot of years. And nobody's gonna say yes to probation under any circumstances. So the banishment will be for 5 years because they didn't negotiate a term. So that's for 5 years, and you can come back for special occasions, and the state and your attorney can work out what those occasions are. But you cannot come back unless you have been approved to do so and notice has been given to the state and they've signed off on it. You are not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any street gang, criminal street gang activity. I assume that you know all of the co-defendants in 22 SC 183572, so you know the people that you're not to have any contact with. I always make this an issue with the state because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all the individuals, their known names and their street names, and any other AKAs they have out there, so there's no misunderstanding, okay? And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So, did I miss anything?
Your Honor, just one thing, if we could put on the sentencing sheet that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
That's for the one
Okay,
guilty.
so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
I'm sorry. Unless you want me to tell you, Brother Schardt, what I'm going to tell Mr. Jackson, I can talk to him.
Yes, just put it all on the record about reporting.
Okay, so he will report on December 19th to 276 Memorial Drive, Atlanta, Georgia, 30303 at 8 a.m.
So, don't be late, don't miss that appointment, because they will come back to court and ask me to issue a warrant for you failing to appear. Do you understand?
Yes, ma'am.
All right, so at this time, is there anything else from either party?
Judge, yes, Mr. Schardt had recommended, I have no intention of leaving my office anytime soon, at least voluntarily, so Mr. Schardt and I have built up a point of trust and communication over the years. I have no problem with Mr. Schardt reaching out to me if there's any exceptions that are necessary. That's great.
And also for the record, I will waive fines and fees for these 3 cases since he's already on probation in another case.
Thank you, Your Honor.
All right, if there's nothing further, then all parties are excused.
Thank you, Your Honor.
All right, so let's watch the camera, and then we'll go watch the Miles Farley plea colloquy.
Your Honor, that concludes the business after probation is done. Can you excuse?
Yes,
See you tomorrow.
all right.
The little shoulder.
On the final plea calendar,
Hold on.
excuse me, position 1 on the final plea calendar.
All right. Position number 1, indictment 23 SC 186907. Marquisha Knox.
All right. So there you go. We will switch back over and continue this plea colloquy for Miles Farley. Now, guys, just as a underscore there, I know it's like, well, Shannon Jackson was acquitted of everything except that one gun possession charge in the YSL trial. The probation he's being sentenced to today for these cases, Max made it clear, got it on the record that this probation sentenced today can be served concurrently with the probation that Whitaker said, all right, I'm gonna, let you serve it down. I'm gonna probate the minimum sentencing because you're a recidivist, so he can run those concurrently. But some of the stuff he was facing today are from incidents separate from the YSL trial, so it doesn't simply boil down to, but he was acquitted in the YSL trial, why is he taking a plea? It's some different charges here. And again, going back to anyone that joined late for Diamante Kendrick, Judge McBurney is open to granting a bond for Diamante Kendrick. However, there's an outstanding out-of-state warrant. It seems to me to be a failure to report. And it's kind of funny, we have Judge Belinda Edwards here say, Mr. Jackson, your probation officer here said, hey, you're going to have a meeting. Make sure you show up for that on time, because if you're late, she's going to tell me, and I will issue a warrant for failure to report. So, very serious thing. Seems like no big deal being late for something, but that's not the case when you're dealing with probation. A whole warrant could be out for you. But if Judge McBurney looks into that, it seems to me, my guess, is that if it's a failure to report for Diamante Kendrick, but Diamante Kendrick was in custody, that's something that'll get cleared away, and, Kayla Bumpus, and I forget the prosecutor's name. But they'll be able to get together with Judge McBurney, make sure the special conditions are agreed upon, and get that bond issued for Diamante Kendrick. So I still think there's a chance for Diamante Kendrick to be home before Christmas. Just take some time to sort out some paperwork. As far as this, I know we've talked about it in the chat already. There was an Alford plea for count 1 for Miles Farley. Everything else was null prost. So we're going to watch this to see how it's presented. Thank you so much for everyone that's been supporting today. I'm sorry to get to these things late. Tat Clouds is out here sniping with a sprinkled gifted membership. Thank you so much. Amber Dawn became a member. I think, did you guys come in here and you're like, oh, I'm not green anymore? Thanks for becoming green again. KL's been here for 3 months. Thank you, KL. Ms. Kim says, good morning, all. Peace and blessings to all. Yes, yes. A very productive morning, too. Like 3 hearings happening at one time. Renee Stevenson says, yeah, and this is interesting, too. They usually wake Yak up 8 hours early, and today they're running late with him. Judge McBurney said that there was, like, chaos down on floor 1. Obviously the ground level where everybody's arriving. Judge McBurney referenced some chaos with everybody getting into the courtroom today. So, of course, though, right, Renee? Thank you for the 5. SS3 Pisces, shout out, I'm an Aries, so you're like my neighbor, my zodiac neighbor. Thanks for becoming a member. Jennifer Divine says, thanks for channel juggling us. It's been a bit of a task. I hope everyone's okay with the order that we've jumped around in. And shout out to the chat. I think it was #FreeThugga in the chat that's like, now we've got to watch Mr. Williams' trial. When is his trial? That's we watched his bond hearing while we waited for any news or motion with this YSL hearing, or for Yak, or for Stillwell. So now we're just invested in new defendants. Thank you again, Jennifer. STS, great to see you, gifting a membership. Thank you so much. Renee says, the chat is on fire. My cheeks, and it hurts laughing so hard. Miss this chat. I'm telling you, it's weird to not have it. And guys, on Thursday, there's a compilation video of some of our Michael Sprinkle moments, a good chat memory. It'll be released publicly, so make sure you check that out for some good chat memories. Thank you, Renee. Heart of Inspiration says, if they don't let this man out, they are giving him a potential death sentence. This is ridiculous. Missed y'all. So this was talking about the man, Mr. Williams, right? It seems like an interesting case. I may have not been aware of who was coming into the house and shot at somebody or got in a fight, but it was initially an assault charge but the victim is now deceased. So the prosecutors upgraded that to a murder charge. So a lot of interesting things going on there with that, the elderly man. And of course, because of his age and it seems like other known health conditions, there's an additional issue for bond, which Judge McBurney said he's taking very seriously. And then you have the added layer of the conditions at the Rice Street jail facility. So a lot of layers there. And this is what bond hearings typically deal with. You know, you hear a lot about the Ayala factors because of the case that Georgia relies on, but really that's to meet different prongs, right? Are you a risk to the community? Are you a flight risk? All these different factors. Why should we be able to make this argument that you should be held in custody and the judge should allow pretrial detention, right? As the defense attorneys would argue, not a flight risk, ties to the community, there's health concerns, you'd be putting him at risk. In other words, county, you could become liable for something that could happen to him if you detain him while he's in custody, right? So it's not just for the good nature of making sure this person's health is okay, but it's also, I think, between the lines, a bit of a consideration. Well, how much of a liability is it on the state to house someone with health risks in a facility, keep them in custody? So all those things argued back and forth. And again, with Schardt, Judge McBurney seems ready to grant a bond for Yak as soon as he gets more information on an out-of-state warrant that seems to be issued, failure to report for probation. So, yeah, and then Shanita talking about the Mr. Williams, not Jeffrey Williams, but this other elderly man. This judge will not grant Mr. Williams bond. And again, if you guys wanted to check out the end of that, this was the link to Judge McBurney's feed today, because we did switch over to watch the other YSL hearings when there was motion. But that link is there if you want to watch it. And Judge McBurney keeps his feeds up, so that'll stay there. Kat Fink, thanks for becoming green again. Good to see you. Survivor Speaks out here gifting 5 memberships. Big thank you. Put an SS in the chat. Thank you so much, Survivor. Law Nerd Amber becoming green again. Thanks, Law Nerd Amber. Touche says, the state says, quote, danger to community, so send them to Rice Street where they will be in danger themselves, convicted or not. And not for nothing, but right, a danger to other inmates. Inmates could be a danger to you. It's like, when you have someone that seems to have more charges from when they're in custody than outside, it's an interesting argument to hear that this person is dangerous, but the things you're relying on to say that are relating to things that are happening while in custody. And Kayla did a good job. She went down to Rice Street, the facility, especially after the December 1st incident. I think we had an acknowledgement from the district attorney that certain charges were worked out, kept off the table, right? No longer going forward. State's not going to move forward with them and prosecute them based on what was worked out. So again, a lot of the stuff that you see when it comes to bond, even pre-arraignment, you don't necessarily see on the record in front of a judge. Mahadi, good to see you, says state played dirty again, withheld info at the very last minute to keep in jail. This is in reference to that out-of-state warrant here for Diamante Kendrick. I think the judge is open to, if that's just a failure to report because he was in custody, it's not going to get in the way of a bond, which is, I think, the right decision. Leah's dad says, when you see judges with attitudes like this, it should make you understand the YSL lawyers being thankful for Whitaker. And what's interesting about Judge McBurney is he gets an attitude, but sometimes it just seems like his attitude's like, all right, that's not even what I'm concerned about, like move it along. And then like it shifts right back in the other direction. I've watched several hearings that he has presided over, and I'll be like, oh, and then all of a sudden it like completely shifts gears a minute later. But it's true, and you have to, I think it's important to know the way your judge is, whoever you're appearing in front of. What do they care about? What do they want to see you argue? What's their pet peeve? Like if they don't like disorganization, don't go up to the lectern with a pile of scattered papers. All these little things, maybe they shouldn't matter, but if they do, you got to pay attention to them for sure. Good to see you, Leah's dad. Nana Banana says, good to see you, Kat and chat and mods. Free these men. Heck yeah. So Shannon Stillwell's coming home with, I think 12 years of probation is the math. And Diamante Kendrick might be coming home. I think there's a good shot that he'll be home before Christmas, as long as this outstanding warrant is just a failure to report. Of course, he couldn't report if he was in custody. Good to see you, Nana Banana. Crushing hard on Max Schardt. You got to see him 2 or 3 times today. Thanks for becoming a member again. And also says, I love being green. Sea Travel is out here sniping. So thank you, Sea Travel. Show Sea Travel some love in the chat. And Sea Travel, your name is making me think of Jeff from Legal Vices. So again, rest in peace to Legal Vices. If you guys haven't heard the news, he passed away on Sunday. If you didn't know Legal Vices, great streamer, friendly to everybody, extremely funny. He's a huge reason why I know so much about the law and a lot of cases. I watched Daryl Brooks through him, Kieran Reed through him, a little bit of Johnny Depp, but he was a panelist on other shows for the most part. Sarah Boone, tons of trials. So if there's trials that you wanted to go back and do a rewind on, go rewatch them. Consider rewatching them with Jeff Legal Vices. We are on a mission to get him a posthumous YouTube plaque. When you hit 100K subscribers, YouTube sends a plaque, so it would go to his family. His link has been pinned in the chat. So if you just want to hit that subscribe button, and again, his content's totally worth it. He'll keep you laughing and teach you a ton. But Sea Travel, Jeff, for Legal Vices, love to talk about maritime law. So that's why I'm thinking of him with your name. So thank you for gifting, and thanks for sparking a memory here. And let's see. Positive Q says, good morning, Kat, mods, and chat. Kayla did okay, but she should have ran a federal and state warrant search. Also, she should have had Yak's home plan, quote, spelled out. So for the second part, she does, but, and McBurney already predicted it, and they both said it on the record. We're not going to put this information on the record. So for that latter part, that was addressed in court. It's just, we're not going to talk about it. We have a plan, but we're not going to spell it out on this YouTube stream. So, but yeah, again, checking for that warrant. I mean, I suppose so. But it also seems like the state wasn't prepared, and that's not an unusual thing. Like, I've watched a bunch of bond hearings, and, there's a decent amount where all of a sudden, like, oh, we didn't know about a warrant. Oh, we didn't know about a warrant, which I think is really crappy in general. So, because it's like, imagine thinking you're about to come home and then you find out you have an outstanding warrant and that's the only reason you cannot come home, right? That's got to be crushing. Red Bunny says, I recall when there was only 8 of us in the chat, like little baby channel. Shout out to Red Bunny. Not just an OG here, but also following this trial from all the way back, and very informative, knows a ton of the little details. So glad you're here. Curious Coco New York says, sends love to the slat chat. Miss y'all. Right? We have like a little reunion this morning. Raylan Encina says, can't even become a lawyer yet hating on Kayla. And let me say, if somebody wants to get into law, remember, you don't need to do something that puts you in the courtroom. And I think about this a lot. Do you think these things being streamed might deter people from wanting to be a trial attorney, or, even things like being a prosecutor, which I think the sunlight is good, right? Obviously, sunlight, if I want to be a shady prosecutor, being on camera and having hundreds, thousands, sometimes millions of members of the public being able to see the way I act in the courtroom, I think that's a good deterrent to shady behavior. But at the same time, not everybody's comfortable being on camera, and I wonder if there's someone that would be a very good advocate that's like, I wouldn't want the Cat Nut Williams chat room criticizing me, and I'm just going to choose a different career path now. So I wonder if like the new age of like online trial streaming is impacting career decisions. But really the point here, there's a lot of fields, that are legal, that don't involve you being on the floor in the courtroom and what has to be nerve-wracking, right? I would be shaky, my voice would be nervous. But yeah. And this is a good point. So Raylan also says, no, I don't think so. I think the stream trials seem to have had a positive impact on people wanting to get in the legal field. And this is, let me get a link to it, you guys. If you didn't see, the New Yorker did a piece with Thugger Daily. And forgot to mention it earlier, but it was super awesome. A nice little read. And Thugger Daily, it's one of those examples of, you know, I might want to do something in the legal field because of everything that, you know, I've done or seen in this trial. So if you want to read a link, here is his post, and in a reply, he has a link to the New Yorker article on him. So really interesting stuff in there. I liked it. Oh, and then get this back up. And you're right. Like, I think Taylor Umbridge, I think she was planning to get into law anyway, but very, very enthusiastic, I think, because of watching these trial streams and being able to learn more about trials in this type of setting. Taylor Umbridge is obviously very motivated for her career in law. So this is very true, Raylan. Flesh of the Gods is also out here sniping. So Flesh of the Gods said 1, 2, 3. Thank you, Flesh of the Gods. Great to see you. And it's Tuesday, right? So are you going live at 8? Let us know. Major Drama, thanks for becoming green. You look good in green. Chris G, good to see you, says free SB. Hey, Cat and chat. And yes, we will have SB free. I'm assuming, I hope we get another, you know, that video of Brian Steele and Keith Adams and Jeffrey Williams leaving the facility. Wonder if we'll get another one of those. Let's see, Tack Clouds also, thank you again, Tack Clouds, out here gifting again. Just sniping a little bit throughout the stream. Paulette gifted 5. Shout out to Paulette in the chat. Hope you're doing well. Love the profile picture. And let's see. Touche says, can't say much for Glanville, but I think Paige and this lady truly want the best for these men. Oh boy. Speaking of bond hearings, guys, if you were looking for YSL content and you can stomach it, go back and watch the bond hearings for the YSL defendants. Steele took up a lot of time, right? You're going to hear how much the state relied on that quote that Viverito talked about and said she would still put in the affidavit the same way. That 24Ms, the diamond, the Lil Uzi Vert forehead diamond. You're going to hear the things that the state relied on to tell Judge Glanville, to which Judge Glanville agreed that Jeffrey Williams was a danger and bond should be denied. So, oh, why did my window go away? Let's get that back up. Law and crime. Get that queued back up. Amber Dawn Them Johnsons, I love this. Says, drop a home in the chat. Love that. Love the house emoji. I think there's like a few house emojis, right? There's one that like is a fixer-upper. There's this one. I think there's one with a tree. And then there's one with like 3 houses. And I only know that like from real estate marketing, you know, doing the social posts. It like probably way overused the house emojis over here on my end. But a good use for them today here. Drop a home in the chat. Happy Annie with the positivity here says Kayla and Max did great jobs. I agree. Amber also says, oh my gosh, we're gonna do it, guys. I bet Viverito. We need one more. One more. Viverito in the bushes. She's gonna be in the bushes in Texas. Oh man. I really can't wait to see the testimony with the second YSL trial from these gang experts? Like, are they going to change their stance on anything? Are they going to concede certain points where they were dumb about, like this 24M diamond? Delicates of Life says, I don't think he should go to Texas. Relationship may not last. Now, this might be, I think this is fair, right? Things can happen and you move out of state, your family could be here, but there is an extra layer here that I think wouldn't be there in ordinary circumstances, right? You hear of someone moving long distance for a relationship, maybe mom's sad about it, family members are sad about it, friends are sad about it, who knows? But here, he's got to leave the metro Atlanta area anyway. So, for what it's worth, there is an additional factor in play here where it's kind of like, he's got to go somewhere. So, I think that, obviously wishing everyone the best, but that's life, right? And the name Delicates of Life, probably perfect name for this type of food for thought. And then Nancy New One Too says, I'm surprised they didn't ask where Mr. Williams would go if released, as his neighbors are witnesses in the case. Nancy New One Too, this might be because we switched the feed. That might have been a question that the judge was going to ask. But this is, I think, a good question. You know, any conditions, you know, neighbors are witnesses. Is there any risk? Probably a good thing to hash out. But we might have just missed it because of the way we've been jumping and juggling the stream. With that being said, thank you guys for the support and the generosity today. Let's listen to this plea colloquy. Even though we know the outcome for Miles Farley, we'll still listen to how it's presented. And I think we're kind of queued up.
Yeah, any of the defendants?
Yes, Your Honor. On Saskia Smith and Mr. Miles Farley, we have a
All right, why don't y'all come on up to the podium, please? All right, Mr. Body, whenever you're ready. And everybody, I'm just going to give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183-572, State of Georgia versus Mr. Miles Farley. Mr. Farley, please raise your right hand. You solemnly swear and affirm that the testimony about giving the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir? Yes, sir. And put your hand up. Could you please state a true, correct, and legal name for the record? I'll let you sign before I ask you all questions. Do you think you want?
And Mr. Body, maybe reposition the mic while he's doing that.
Yes, sir. Mr. Farley, could you state your true, correct, and legal name for the record? Farley. And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine? No. Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here? No. And how old are you, sir? How far have you gone to school? I got a bachelor's degree. And are you able to
also speak into the mic, please?
26 and got a bachelor's degree. And so are you able to read, write, and understand the English language? Yes. And do you understand you are charged in indictment number 22 SC 183-572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm in the commission of felony. You understand you're currently charged or indicted with those counts? Yes. And do you understand that you have the right to plead either not guilty, guilty or not guilty to these charges, and if you pled not guilty or remain silent, you may receive a jury trial? Yes. And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir? Yes. And are you satisfied with the services that your attorney has provided? Yes. And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case? No. And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney